Yeah, good evening, sir. Now you're audible and visible also. Okay, before we start with our session, I will tell Advocate I'll request Advocate Vaishali Tikle to give a small introduction about the sir.
Good evening, sir. Good evening. And a very warm good evening to one and all connected for this webinar series. Today we are fortunate enough to have with us Advocate Jayant Jaibhave, and sir is going to talk on the Civil Procedure Code. As we all know that it is a vast subject, so we have bifurcated into two parts, part 1 and part 2. So today will be a part 1. And I take this privilege to introduce him. Sir has 32 years of standing in the field of civil, revenue, land acquisition, criminal, arbitration, consumer, cyber law, conveyancing, matrimonial law, banking, and banking law. Sir has authored myriad books, namely Civil Pleadings, Conveyancing and Drafting, Cross-Examination, CPC, Approach to Trial, and Hindu Succession Act, etc. Sir was member of Maharashtra State Law Commission and also member of Bar Council of Maharashtra and Goa. He was vice chairman in 2008-2009 and chairman in 2010 to 2011. His noted achievements, amongst others, are that he coined the idea of e-library at NASIC in 2005, and during his tenure as a vice chairman, he established computer law libraries throughout state of Maharashtra and Goa at 425 places. We welcome you, sir.
Thank you.
And I hand over the mic to you so that you can start the lecture. Thank you, sir.
Good evening to everybody. And I think we are slightly late. So without wasting any time on the other part, let us directly go to the subject. First of all, let me congratulate the Family Court Bar for initiating this online lecture series, because particularly we all are suffering from these circumstances of the coronavirus, and we have to take our care. I hope that you all are taking your care and your family care. At the same time, you have to keep yourself busy. Particularly for a lawyer, you have to keep yourself busy by mind, because if your mind is fresh, then your body is fresh. So it's very good. I can say that innovative concept of starting these online lectures, because physically it's not possible. So congratulations, Madam Shraddha Madam and all her team for initiating this program. Now coming to the topic of a civil procedure code. Today I will just give a bird eye view of a civil procedure code in this first lecture, because I hope that we all lawyers, whether we are a junior or whether we are a senior, whether we are practicing actually civil laws or we don't have practiced the civil law, we had an impression that the civil procedure code is something very heavy material and having the huge provisions of the law, a bulky document, and it's always troublesome in the minds of a lawyer to go to the particular provisions because of that particular bulkiness of the code. And therefore we have to understood exactly what this code is made for, how it is made for, and what are its content as such. And therefore, first of all, as an advocate, a basic rule of an interpretation is that whenever words are used, you have to see the exact grammatical meaning of the word used in any statute or any law. So this is a civil procedure code. So the first question should arise in the mind of a practicing advocate, that why it is code and why it is not an act. Because we also have an act also. Evidence is an act. There are many other acts. But also at the same time, we have some codes also, like a civil procedure code. So why it is said to be a code and not an act? That should be the first question which should arise in the mind when we have to give a bird eye view for this provisions of the civil procedure code. What is the exactly meaning of the code then? Word CODE, code. If you go to the dictionary, you will find that it's a collection of material. It's not a single one document, but it's a collection of various other documents also. And for that purpose, it is used as a code. In a state of Maharashtra, if it has to be simplified, then it is said, in a Marathi, it is said as a sangraha. Code means a sangraha. So it's a collection. So what is collected in this civil procedure code should be the anxiety in the mind of the practicing lawyers. Because I have completed 35 years of the practice, and till I have written the books on this subject for last 10-15 years, I have not given this thought that what exactly contains in this entire document, why it is not an act and why it is a code. See friends, in the first part, there are sections. From section 1 to section 158, sections are there. You know that the normal acts are designed with the sections, and always the rules is a separate document. You get the rule. You can go to the any other enactment. For example, Maharashtra Regional Town Planning Act. It is act, and you will get a different rule under that particular act. Likewise, in act itself, there is a rule-making power given, and by using that rule-making power, rules are framed. So it's an independent document. That is not the case of the Civil Procedure Code. After section 1 to 158, you find that there is schedule 1, and that schedule 1, which is most frequently used by the practicing lawyers and the judges, that are the orders. These orders are from order 1 to order 51. So it's another annexure to the section. So 151 to 158 section plus schedule 1. Schedule 1 means orders from 1 to 51 orders, having various rules, which are the exactly numbers of the rules. I don't want to tell you. You may have a botheration of the number and figure. It may go into big number. Forget that. But the question is that these two things together we are using in the civil procedures, in the civil courts, for conducting the civil trials or for conducting the other civil matters. So sections plus orders also. What is the nature of the order then? Sections are section. It's a substantive law. It's a provision of the law.
The people have dropped drastically. They had read 250 and they dropped drastically.
And we had a rules. Hello? 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 I hope that you are hearing me. So this second part of the rules is an attachment of this one single document of a civil procedure code. It doesn't end to this of the orders only. It goes further. And that should be understood, because we normally forget that something more is there. And therefore, when there are live lectures, it is always tried and interacted with our colleague advocates that what is other than odd sections and orders in the civil procedure code. You will find, you will have to just verify the index of the statute of the civil procedure code, and you will find that there is appendix A to H, which is attached to the document of the civil procedure code. What are these appendix? You have to see that appendix. For example, appendix A, you will find that there are different types of small formats of the pleadings given for the different types of the suits. There are different types of the written statements given with minimum required pleading contemplated in that particular format. So these formats, if it is A, it's a formats of the pleading, then B, C, D relating to the various other parts, such as the summons is there, decree is there, many other things which we are required for completing the entire procedure of this civil suit. So broadly speaking, the code Civil Procedure Code, it includes sections 158, orders 51, and also the appendix A to H. Here I want to draw your attention that what is the nature of a section and order that you know? We use it as a law. Then what is the exactly nature of the appendix which is attached to this Civil Procedure Code? Because now it's a part and parcel of that document of the Civil Procedure Code. For that purpose, you have to be cautious, and you have to, during a practice also, and during your academic study also, you have to give some different type of the attention towards this appendix part, which generally we are not giving. Okay, okay. Well, I hope that you all are getting this point. So this CPC means three things. First is section, another is an order, and then subsequently it is the appendix A to H. It is one and the same document of the civil procedure, and therefore it is called as a code, a collective part of the sections, orders, and appendix. And for that purpose, we have to understood that it is said to be a code and not as an act only. It's a collection of all these things. Now coming to the importance of this third part. Important of this third part. You know how the sections are used. You know how the orders are used. How this part of an appendix is an important in a practice. What is its legal meaning? How it is binding, or it is just sort of a guidance. Normally, we all in a law colleges refer Jhabwala. And then we had some good guides. So there is a general impression in our mind that some sort of a guidance is given by CPC for making the drafting, making the pleadings. If I to draft a suit for a specific relief act, some guidance is given by form number 46 or form number 47. That is contained in Appendix A. As I told you, in Appendix A, various forms of pleadings are given, different types of a money suit, an injunction suit, a declaration suit, a specific relief act. All these suits, how they are required to be pleaded, and which is a minimum required pleading you must draft in that particular suit is given in Appendix A. Similarly, you will find a written statement also, which is a minimum required pleading there in that particular type of a suit. This guidance is given by Appendix A. Then what is its nature? Whether it is a simple guidance or it is to be followed like a law, because ultimately it's a part and parcel of the Civil Procedure Code. And Civil Procedure Code in totality, it is a law. Therefore, the lawyer must give a thinking that what is the binding nature of these pleadings given in this Appendix A. For that purpose, I will just refer you only one type of suit and its format given there. A specific relief act and the suit for the specific performance. There you know that you have to plead. Suppose you are a purchaser, you have to say that I am ready and willing to complete my part of performance. I am ready to make a payment. Suppose a contract is of 10 lakhs rupees and 5 lakhs rupees you have already paid. You have to say that I am ready to pay remaining 5 lakhs rupees. This requirement of making a pleading of readiness and willingness is out of two things. First of all, it is a requirement contemplated by the Specific Relief Act under Section 16(6) 1C. There it is said that in a Specific Relief Act that whoever wants to claim a specific performance, he must specifically aware that he is and willing, ready and willing to perform his part of a contract. Therefore, if you are not making that particular pleading in your suit, that plaintiff is ready and willing to perform his part of a suit, what is the fate of your suit? You know that. The suit will be thrown because there is no required pleading of readiness and willingness. Apart from the other part of an evidence, because of an absence of this pleading, it will be thrown. Now, this part of a pleading is also mentioned in form number 46 and 47. You can note down and you can see the document of the Civil Procedure Code. Two forms are there in Appendix A, form number 46 and form number 47. There also, in a minimum required pleading for the suit of a specific performance, you will find that a pleading is required that a plaintiff is ready to perform his part of contract. And apart from that, there is also another pleading, which we are not following or mostly which we are forgetting to add in our pleadings. And that is the plaintiff has also applied to the defendant. The word written in that form number 46 is that, and 47 is also that. The plaintiff has applied to the defendant, but defendant has not thereafter responded. This word is there. So readiness, willingness, if you are not making a pleading, your suit will be defeated because of the absence of the pleading. And if you are not mentioning in your suit this another line, which is given in a form number 46 and 47, that plaintiff has also applied to the defendant, but defendant has not responded. What will be the effect? That will show you what is the nature of the guidance of Appendix A, its formats of the pleading and the requirement of the pleading while conducting the civil suit. You will find that if the pleadings as per 46 and 47 form are filled, the suit will be defeated. You can get number of case laws of in a high court which will prescribe,
Hello.
which will
Yeah.
enforce this law. That
एक्चुअली हुआ ये है कि बहुत सारे लोग आ गए हैं suddenly. There are around 288 participants, so the connection is little slow.
Rahul sir, chup.
So
You dumbass, chup.
so the question is that these three together we have to go for understanding the nature of the civil procedure code as such, and that's why it is a code and not only the single document of the section. Not we are restricted to this particular part for the civil procedure code. We have to go further and see that there in the civil procedure code, that particular aspect is of the state amendments and high court amendments which are included in a civil procedure code. Also for that purpose, you have to see which law permits the state government as well as the Bombay High Court to incorporate the various amendments in the civil procedure code, because the Central Act prior to 2002 and after 2002, these are the two different situations as far as the state amendments are concerned and also the High Court amendments are concerned. As far as the amendments are concerned, state amendments are concerned, you can go from section 121 in a CPC and you will get that all right from section 121 onwards up to section 135. There are ample power given to the state government also and also to the Bombay High Court particularly to prescribe their own amendment. So this amendment becomes a part and parcel of the civil procedure code. How important these amendments are, we'll see that in a last part of our today's lecture only. And that for that particular purpose, the civil procedure code in totality will include all these four things. sections, orders, Appendix A, and also the High Court amendments. Including all this, it is a civil procedure code, and for that purpose, we have to look towards this document when we are talking about putting a bird's eye view on this particular document of the civil procedure code. Now coming to the another part, there is a number of provisions. There are sections, there are orders. Another question for making a proper analysis and for getting an understanding of this entire enactment, we should think of that what sequence is there, in which type of a sequence these particular sections, orders are designed together. Whether it is something, a logical sequence which has been created because number is big, and because of that number, perhaps we get a botheration for going to the provisions of sections and orders of the Civil Procedure Code. For that purpose, as a student of law, my own perception which I am sharing with you, you may have a different perception. For my own perception, for understanding the entire sequence of the design of the Civil Procedure Code is that it is based on the simple principles of natural justice. A same sequence as it is required for following a natural principle of justice is there in an entire design of the sections and the orders in the Civil Procedure Code. We will restrict ourselves today to the first part of the litigation, that is a suit. Suit is filed, pleadings are prepared, suit is filed, and suit is decreed. To this particular part, we'll see how the sequence has been designed in this Civil Procedure Code. For that purpose, we know the natural principle of justice. We need not know, even a layman knows. Even if a small person from a society, if he is held up for some, or he is catched, he will ask, what is my wrong? You explain me my wrong. So in a natural principle of justice, suppose you have to file any simple complaint regarding any grievance, suppose to not to the court but to some authority, then the sequence is simple. You will file a complaint in writing. That complaint will be filed to some competent person. That competent person will send a notice to the another person against whom you have made a complaint. The notice will be served upon him. He will appear. He will reply. He will make his say. He will file his document. Your complainant will file his document. Both will be heard. Decision will be given. This is a simple, logical sequence which not a lawyer but even a layman understands. Now see the Civil Procedure Code sequence. First part, we have to plead. Pleading is the best of the civil suit. So you have to plead. And therefore, you can see the sequence. You have to plead a suit. You have to file a suit at an appropriate place where the jurisdiction is there. You have to follow certain direction. It should be with the wakalatnama, some recognized agent from your side. There should be some appropriate parties in that particular suit. Once you make this filing, then the another part of the court motion starts. Now here you see Order 6, 7, 8. They deals with the pleading. Three basic orders. 6 in a general, 7 about the suit or plaint, and 8 about the written statement, the other counterpart of the suit. So these are the basic core of the pleading which relates to Order 6, 7, and 8. Come to the filing of the suit or party, right from party and filing. This entire episode, making a party, filing to an appropriate place of an institution, then another part of having a recognized agent there. This you can see that Order 1, 2, 3, 4. 4 orders. This take care of these particular aspects of filing of the suits. Then come the another aspect, that suit is pleaded. It is filed at appropriate place. Immediately the next natural recourse is of a summons. So Order 5 relates to summons. the various different types of the summons, and that too in a very logical sequence. First, you have to go through court, you have to send by registered post, then if it is not served, you have to follow the another procedure. Lastly, you have to go to the public notice, because the public notice is not a good notice. It is not a good service. And therefore, the logical sequence has been taken in the civil procedure code. The second, order 5, it relates to the summons. So see now, right from order 1 to order 8. 1, 2, 3, 4 filing, 6, 7, 8 about the pleading, 5 about the summons. It's a simple 3 stages of the natural principle justice which takes care. Now this is understood to everybody. Now slightly when we talk about the advocacy, and that too also making some skillful advocacy in a civil practice, the question comes about a proper appreciation of the second part of these provisions, which starts from order 10 to order 13. Particularly, I will just give a brief reference today about this provision, and tomorrow, if we have to talk about the speedy justice now, we have to talk about the conducting a civil trial speedy way. These provisions which are useful for us, which we are not using frequently, that should be seen. And they are right from order 10 to order 13. Here the first question to a practicing lawyer is that, what is the really first stage of a hearing of the suit? When we discuss this particular aspect, many times our impression is that after framing of the issues, the next stage is witness list, and after the witness list, the another stage is of a hearing of the suit. It's all right. It's not wrong to say. But read order 10. The wording of order 10 starts with the word that on a first hearing of the suit. What is that? We have to give a thinking to this particular aspects of order 10. Why this order 10 is there, and what is the role of order 10? The suit is filed, the defendant has appeared, he has filed his written statement. So now before court, two basic pillars of the suit, that is a plaint and a written statement, they are before the court. Court has to give a thought upon this pleading by making an assessment whether a particular facts are admitted, which facts are denied. For proper admission and denials of the fact, what more can be done by the court, whether court can call some documents, whether court can examine some witness before framing of the issues, and that too by the court themselves, and that making that particular exercise is restricted to the purpose of making a proper admission of the facts in controversy and differentiating a disputed facts from the admitted facts. You see rule 1 of order 10, you will find that it's an obligation casted by rule 10 of order 10 to make an endorsement on a plaint by the judge regarding the admitted facts and the disputed facts. And also the word used is there shall, the court shall make an endorsement upon the plaint regarding the admitted facts and the disputed facts. The question is that this is an adjudication, and in this adjudication, pleading is the best. In this particular pleading base, the question is that which facts are admitted need not be proved is the law. The proof is required now only for the disputed facts. And this analysis is to be done by the judge by using the provisions of order 10 itself. And therefore the exhaustive order is there. We'll see the details thereof order 10 in tomorrow's lecture if possible. So order 10 is to be used after the written statement is submitted by the defendant to the court, it is our duty, if the courts are not making this assessment, friends, and if you want a perfect adjudication, if you want to shorten the time for conducting the civil trial, then for that particular aspect, it's our responsibility that we should point out to the court that honorable court, kindly see, and these are the admitted facts, these are the disputed facts. Many times we see that the adjudication goes on even on admitted facts also, and for that purpose the issues are framed, which are framed even on an admitted facts, and therefore the time is wasted. So as a lawyer, for doing a better advocacy, perfect advocacy, it becomes our duty to point out all these provisions to the court. You can see order 11 and order up to the 1113. There are many other instruments which are in our hands, which are particularly for the purpose of bringing all the admitted facts, all the material required for adjudication before the court. You can use the interrogatories, you can use the notice of admission, you can use notice of document, notice to admit document, you can use order 12 also, you can use order 13 also for filing of the documents. Filing of the documents is to be seen very carefully. You can see order 7 when plain is to be drafted. Whichever documents on the basis of that document you are making a pleading, that document must be filed at the time of filing of the suit only, which are the main documents. Some supplementary documents you can subsequently also file. But as far as order 7 also and rule 13 also, order 13 also, if you can come to combinedly, if you can see the provisions, it is a mandate that the document on which you rely for making a pleading in a suit, that all documents should be filed at the time of a filing of the suit itself. And same thing for a written statement. The defense which you are taking on the basis of that documents, main documents, that should be also filed along with the written statement. And apart from that, the defendant should be careful. If a plaintiff has not filed that documents, which are the documents having the pleading, reference of a pleading, he can object in a written statement that these documents are not filed, and he object for filing these documents. And that particular objection is a very strong objection. If it is contested, the plaintiff may fail to make the production of these documents without giving an appropriate explanation. If he can't give an explanation that I forgot it or I thought that it will lost, no, he has to give an explanation to this extent that it was not available on the date when the suit was filed. This can be only accepted. If it is subsequently made available, he will be permitted to file. So that is a combined effect of order 7, order 8, read with order 13 also. So this part in between order 10, 11, 12, 13, this is very important for the conducting of the trial. If we have to see towards the span of the litigation or the speed of the litigation, this you can use effectively, and you can reduce the entire scope of the litigation adjudication. The admitted facts will be recorded. The another facts, notice will be given to admit. Document notice will be given. If the documents are admitted, they need not be proved. If in spite of a notice, documents are not produced or they are not admitted, the effective use can be done with the help of the Evidence Act. Because you know, the section 66 of the Evidence Act gives you power to object that particular admission of a document for which notice was given and reply was not given. So combinedly, by using these provisions with an Evidence Act, you can effectively restrict the another party for a lengthy evidence, and your evidence will be short but and with a quality one. So this is the part of the in between investigation after the pleadings are completed, which is often most important thing. We must see the details of this particular aspect afterwards. So then the issues are there. Issues are to be framed. framing of the issue is not a mechanical process, friends. We have to see that whether court is also considering the admitted disputed facts properly, and really a burden is put on a proper person in light of CPC, also in light of an Evidence Act also. It's the duty of the advocate, because advocate can only make an assessment of that, and therefore you can always object for the making of the framing of the issues. You can make an application, you can move an application, you can delete the issues, you can add the issues. That is your own advocacy, the way you want it should be properly done. So it's order 16, and then order 14. Then from 15 to onwards, it's all provisions relating to the conducting of the suit, witnesses and adjournments, and the order 18, which is particularly of an evidence. And lastly, order 19 and 20, judgment and decree. So see that entire order sequence. It's very simple. Related to the natural principle of a justice, a simple sequence can be understood by preparing your own chart, that this is the stage and here this provision is applicable. Equally, you have to make a comparison with the sections also. We don't have a time to make all these comparison now, but of course you can see that to this particular order which section is connected. There is a connection, because ultimately a section part is a substantive part of the law, of the code, and the rules being a schedule to that particular sections or the civil procedure code. This particular part is a supplementary part. So what is the main provision of the section, that is also equally important. You can make that comparison, and for that purpose you will always get a sequence that right from section 9 to 35, all this order 1 to order 20, they are connected by section 9 to 35 to them, because after order 20 it's immediately order 21 for an execution. And also, if you can see the section part after 35, right from section 36 to 74, you will get the substantive provisions of the execution of the law, execution of the decree. So this particular sequence of sections and orders, it goes hands to hands, and it is correlated on the different stages of the suit. We have to understood this particular aspect. So friends, this is the sequence as per my perception. This is important. And once we understand this particular sequence, then it's easy to reach up to the appropriate provision of the law. Basically, whenever a question of the provision comes, the courts also expect that we should help them properly. In fact, it is expected that whatever application you are moving, it should be with an endorsement that this particular application is made under such and such section, such and such order. And if it is under that particular order, it should contain that particular required ingredients of that particular law also. For that purpose, our mind should properly understood the sequence of the provisions of the law as they are designed. Because many times we feel bothered for going to that particular provisions, or nowadays we had a habit of going to a mobile and going asking for some case law, and that case law is always given to the courts. Perhaps my own perception is that the lawyer must develop a habit that first of all, it will be referred to a section, then it will go to the rules, then it will go to the case law. There is also one manual, civil manual, which can be used very appropriately, which we can discuss afterward, and then you can go to the case law, because case laws are ultimately an outcome of that particular dispute, on which particular facts that the particular dispute is designed. That particular perception is there in that particular case law. So it's many times it's not possible that it will match to your own facts, but your facts are appropriate. And if you find an appropriate provision of either section or order or manual also, I think you can correlate that, and that is more impressive before the court also, because court perhaps appreciate that, and therefore case law is also always an important thing. We can't say that case laws are not important, but for having a good habit, let us think of this manner, whether we should first go to the case law and then to the provisions of law, or first to the provisions of law and then to the case law. That is, of course, an individual perception of every advocate, my own perception is that better to go in this sequence as far as civil procedure code is concerned. So here, this sequence part should be, I think, completed. We had a short time. I will just now in this particular lecture, today's lecture, refer to some of the important aspects of this entire code in general. First part, which I want to place because in many lectures I found that this confusion happens. Pleading. The question is that the suit is pleaded. Pleading means a suit, a plaint. The question is that the application for an interim injunction, which normally in a trial court it is called as an Exhibit 5 application, or it is called as an application under Order 39, Rule 1, 2, whether the contention raised in this particular application can also be treated as a pleading. You can simply answer to this question by referring to the definition of the pleading word itself. It is defined in the Civil Procedure Code. It simply says that pleading means it is only suit and a written statement and a counterclaim and the written statement to the counterclaim. 4 things. Because counterclaim, the order 8 itself contemplates that it's nothing less than the suit. All the requirements of the pleading, as they are for the plaint, they are also for the counterclaim. So naturally, when a counterclaim is there, a written statement becomes an essential part for the counterclaim. So 4 parts of the pleading are there. These are the suit, written statement, counterclaim, and the written statement to the counterclaim. The Exhibit 5 application or the interim injunction application is not a pleading, and therefore neither the amendments are possible by using the provisions of Order 6, Rule 17 or any other provision, nor it can be treated as a pleading for the purpose of any evidence also. And for that purpose, the concept of the pleading should be very clear, and Order 6, I think, gives you the basic guidelines how the pleadings are to be made and what are the requirements of the pleading that has been given first in general, in detail in Order 6, which is applicable to plaint also, which is applicable to the written statement also. Then it specifically, Order 7 speaks about the plaint itself only, how the plaint should be there, how the title should be there, how the number should be there, how the party should be there, cause of action should be there, valuation should be there, limitation, relief, and also your verification of the last part of the plaint. How should be there, in which manner that verification should be there, that is given in Order 7 itself. So same, when you have to go to the written statement, Order 6 read with Order 8, that is the entire procedure for you for making of the written statement. So this pleading aspect is important, friends. This is the basic for the suit that I did not tell to you. You know, as a practicing lawyer, the pleading is the best for the civil suit. The another aspect, important aspect, is a cause of action. Because cause of action as such cannot be designed, they are defined. But a cause of action is important. So what is this cause of action? If you read the law on this particular aspect, many small, big interpretations of a cause of action you will get. But it's a simple bundle of facts. As per me, as per my own experience, I'm telling, bundle of facts, referring to which you are ultimately claiming the relief. So the bundle of facts connected to the relief together can be said to be the cause of action. And for that purpose, a limitation being an important aspect, you have to refer a particular time when this cause of action has started, because ultimately you have to ultimately go for the law of limitation, and you have to plead that your particular suit is in time, and then for that purpose, cause of action and limitation are again correlated to each other. So another aspect of the suit is the valuation of the suit. Valuation, whether it is on the basis of the Code Fee Act or it has some other laws. For that purpose, we must see the Suits Valuation Act. And for that purpose, the valuation of the subject matter is basically on the provisions of the Suits Valuation Act. If there is any dispute upon the valuation, if the plaintiff says that it's a 10 lakhs rupees valuation, and if the defendant comes with a case that no, it's not a 10 lakhs, it's 50 lakhs rupees valuation, so dispute arises, then it is an inquiry contemplated under the provisions of the Suits Valuation Act, where an inquiry is to be made. The person referring a valuation in a pleading, in a suit, has to lead an evidence, and thereafter making an opposed to that evidence, ultimately one has to go for the valuation. Generally, the valuation made in a plaint, unless objected, is to be accepted. Of course, it's the right of the ministerial part of the courts. They can object because the question of the valuation is there. Valuation will be again reflected on the court fees, and also jurisdiction questions are there. So for that purpose, the ministerial objections to be taken by the office of the court is always there. That is different. But apart from that, the basic right of making the valuation is with the plaintiff, and he can do this particular valuation. So valuation is also important. For that purpose, as an advocate, we must properly understood not only CPC, but also the Suits Valuation Act along with the Code Fee Act also. Because if you are making a particular type of value, suppose many times in a trial court, this question comes that if in a partition suit is there and some property is already sold out by one of the co-owner, and you want to make a cancellation of a sale deed. In that questions, what is the valuation is to be done? Whether it is a valuation of that sale deed, suppose it's a sale deed of 25 lakhs rupees, whether you have to value it on a 25 lakhs rupees and make a court fee stamp according to that. It differs due to, you can see the law on this particular aspect. If it is a agricultural property, it's a non-agricultural property, the law refers. But these types of questions comes before you, and for that purpose, if a dispute is raised, Suit Valuation Act is the base for making an inquiry. Also, the help of the Code Fee Act is to be taken by using these two provisions, two law along with the civil procedure. We have to go for the finally the valuation of the suit. Of course, limitation is important. Law of limitation depends on the particular facts, cause of action, and the relief which you are claiming. On the basis of that, you must plead about at least 2 lines that your suit is within limitation, so as to have a safe standing for your suit before the court of the law. And ultimately, the last part of the relief is there. Here, the another part of the suit, apart from a plaintiff of a defendant, has an additional benefit of a counterclaim. Here on a counterclaim, the Order 8 itself contains a provision that for making a counterclaim, you have to refer to entire Order 7. Whatever you are pleading for the plaint, you have to accordingly plead. You have to see, you have to plead that cause of action is there. You have to plead the valuation of the counterclaim, the limitation of the counterclaim, and also the relief of the counterclaim. These are to be distinctly pleaded with allow verification, as it is already required there for a written statement also. For counterclaim also, you have to be there. Counterclaim, whether it can be only with a written statement or subsequently also it can be made. For that purpose, you will see a divergent view. My own perception is that it is better to file along with the written statement. But out of some circumstances, if you could not file it along with a written statement, my own practice, which I adopted and I succeeded in that particular aspect by arguing the matter, that along with an application, by explaining why this particular counterclaim is subsequently filed, by explaining to the court, by making an application, and by taking the permission, it is always better to file a counterclaim before the court. This particular process helps you from a further controversy that the counterclaim was not with a written statement or without the permission of the court, and therefore you you have to affix the court fees to the counterclaim. In a written statement, that problem is not there, but when you are putting a court fees of the clients to the counterclaim, it's always better to put yourself in a set position by taking a permission which is normally granted if your counterclaim is in a limitation. The only condition is that it should be in limitation. And for that purpose, it is always better that all controversy connected to the same subject matter should be resolved in the same particular suit. Of course, if it is between the same parties. And therefore, for that particular purpose, a better practice, as per my opinion, is that we should go for, if we are filing a counterclaim subsequently from the written statement, then you must go for an application, independent application, take the permission and file a counterclaim is a better procedure or practice to be adopted by the advocate. So these aspects of the entire pleading once over, one important subject of a jurisdiction remains which should be read in a CTC properly. Particularly in section 9, the concept of a jurisdiction which is divided into two parts. One part is an express bar and another part is an implied bar. All suits are triable by the civil court unless and until expressly barred or impliedly barred by law. Express bar need not require much discussion. It is already an express thing in a law, some statute, and that bars you filing a suit. The question is that how the concept of an implied bar should be seen. I had an experience for this, which I'll share. It's a question of everyone's own perception. A municipal authority made certain building plan, and that building plan was wrongly approved. On that particular basis, a suit is filed. The question is that making a pleading against the municipal authority that a plan is not properly is illegally approved and it should be cancelled or it should be declared to be illegal. These types of pleadings are made. It may be in various different types of litigation. Here the question is that making of the plan, approval of the plan, and its objection, whether it has a different distinct forum. You can see that there are various forums. It's a corporation, it's a Municipal Corporation Act. It is also the Regional Town Planning Act, Maharashtra Regional Town Planning Act, where you will find that these types of an objection can be raised to the competent authority for making an appeals or even in the sort of some complaints, and that can be entertained. So it's a complete scheme contemplated on that particular different statute. Here, there is no express bar as such in a particular law. In suppose a Town Planning Act, there is no particular bar. Or suppose in a Corporation Act, in that particular aspect, even the concept of the implied bar can be borrowed here, and that particular implied bar will be applicable. So the concept of an implied bar is something like this, that express words are not there. But for this particular wrong, a separate remedy, independent remedy is provided. You can go to that remedy. It is specifically made for that particular wrong, and by using that particular remedy, you can cure your defect. If that is the situation, this concept of the implied bar operates, and that is really important to be understood by all of us when we do practice, because in a stroke of the practice or while making a pleadings, we do various pleadings. We include corporation also, sometimes state also, some other statutory bodies also, but already some remedies are there. So these types of a concept, which I particularly, my own perception is that it is to be looked into this manner, that express words are not there, but some appropriate remedy, a complete form of a remedy, not a certain only slight provision of making some complaint, but a complete form. The complaint is there, the inquiry is there, the decision is there, the appeal is there. This is a complete mechanism for adjudication or redressal of that particular wrong. For that particular aspect, I think is more important. I hope that I'm not exceeding the time, and the another 2-3 aspects remains still to be explored. But as the time schedule given to me is of 6 p.m., it is completed. I am just of the opinion that the Civil Procedure Code is the simplest document. It does not have complications. It is designed totally on the basis of the natural principle of justice, with an aim to give an aid to plaintiff also and defendant also to put his fair case before the court. For that purpose, pleading must be precise, perfect, because the pleading, if we are going with a big pleading, the liability obligation of proof for entire big pleading is casted upon. And therefore, always the old tradition of the lawyers have always propagated that the pleading must be precise and perfect. Similarly, the filing must be precisely done, perfectly done. All the required documents which are necessary must be filed. If it is not to be filed in the form of original, it is to be filed in the form of Xerox. All right, Xerox, but with verified copy from the appropriate authority of the court. We have to file it before the court. Similarly, when we are on the side of a defendant, we must be prompt to file a written statement in a stipulated time. We are waiting for 30 days, we are also waiting for 90 days, then also we are not getting the time, or we are not getting instructions and documents, and then it delays, then application, and then many times the law is now strict. It's not so liberal that your written statement can be taken at any time without any proper explanation. The latches and the delays are going away from the entire things. So this particular aspect should be understood. The important aspect of the amendments of the pleading, on which I would like to comment, but it's just slightly time-taking thing because it is to be seen in light of the High Court amendments, and that too in light of the new amended CPC 2002, the amending act of the 2002. So what is the effect of section 30 of that amending act upon order 6, rule 17, how it is to be linked, and what is now the status of the state amendment of the Civil Procedure Code as such in general upon the entire use of this Civil Procedure Code. It is to be looked in that particular perception. So I request the organizers to let me complete that on the next opportunity whenever possible. So this particular aspect, I think we should concentrate. And I again further congratulate the organizers for starting this online lecture series. My all best wishes and my always support for completing all this good venture. Thank you very much.